Yeah, so like I was saying, I just want to cast our minds back to the tutorial question or similar tutorial questions and exam type questions that come in connection in relation to bail applications. And having watched the Ace Magashule bail application, which the video which was put onto Moodle for you, you would have seen that the court makes, and even the counsel for either party makes reference to this decision of Akerson. And the Akerson decision pretty much looks at the sections in the various delineated parts of the section of section 60 and puts into context or tries to give meaning to those words. So, what do we mean when we say what is the likelihood that he will abscond bail? What are the outside external factors or real life factors that would help a court determine that possibility or that likelihood? Obviously, we can't possibly get a guarantee. So, in that sort of question, where you're meant to make argument on one side for the granting of bail, on the other, that bail be refused, and finally, in the place of the magistrate to make a decision of whether bail should be granted, if it's granted, at what amount, and um, further, what conditions to attach, for each of those roles at role players, you are looking at section 60, and you'd have seen that there's arguments to be made on both sides using the same sections in the act, right? And but obviously seen from the other's point of view, the other's perspective. So, and you would have seen from the Ace Magashule decision how that's done, and that even the court in its decisions also refers to section 60, also refers to Akerson to do that. So when you look at it this way, and so this is taking the various sections and looking from Akerson. So you take whichever particular factual scenario has been given to you, and when you're standing up in court doing a bail application for a client or opposing one if you're the state, these are the factors. So the likelihood that he will abscond and forfeit bail, the likelihood that he will tamper or interfere with witnesses. And the third point, which is also important, is that what prejudicial effect that remaining in custody like that would have for an accused person. And but what does that mean, and how practically through the cases we can see how the courts or what factors the courts have taken into account there. So here essentially are those delineated ideas or clues or things that the courts would want to consider or want to be aware of or know of. Right? So emotional roots, occupational roots, family roots within the country, and even obviously within the province, because you don't just, depending on the nature of the matter, you're not always only ever talking about accused persons who have the possibility or the means to leave the country. It might just also be something like leaving the province. So and setting up roots somewhere else, or so again, looking at does he have permanent employment here? In the example, in the question that we looked at, he's at school. Does he have a job here? Are the people who depend on him or the people he depends on, are they here? So those sorts of clues or indicators, the likelihood of him just upping and leaving are less likely. What sort of assets, not only in the country, but again in the province, what means a person may have to flee. So here we're talking about assets in the form of money or cars or airplanes, passports, those sorts of things. But property owned in foreign countries, foreign bank accounts, and that sort of thing. So when you work through it, you'll see that there's arguments to be made on a particular problem scenario, factual scenario given on both sides. So something to be said there, and that's essentially how you should work on that. So any questions to make us, seeing as how it's just you and me? Excuse me. Any questions on that tutorial question? And if you've had an opportunity to look at it further.
Okay.
Yeah.
No, I'm happy.
You're happy with. All right. Okay.
Yeah.
So the topic, and we're looking at two topics today because they go hand in hand, and I've simply just had to split them up into two because Moodle won't allow me to upload such a big file because there's a lot of audio involved here. We're looking at the charge and the plea.
Yes.
And although we looked at bail, and bail happened in a court, it still wasn't, in a sense, technically the start of the trial. The trial starts when the accused is formally charged in open court or in court and then is asked to plead.
Mm.
And once that happens, he is then said to have been arraigned. And then the trial can start. And when we say the trial can start, we mean that the prosecution or the state can start leading its evidence, and that's making its opening statement, calling witnesses, etc. But that only happens once this arraignment happens. Now, uh, in a formal fashion, in the High Court or the Superior Courts, it's called indictment, and in the lower courts, it's called charge sheet. And how that happens, and how to say that the accused person has been arraigned or is being arraigned, is that the charge must be put to the accused. And this charge is drafted. So if we follow the progression, there's a crime happens, it is reported, it is investigated, um, whatever, however the witness statements, etc., are gotten, and other information and evidence is gotten from the police, the docket then goes to the prosecutor. The prosecutor then looks at the docket and determines what charge to draft, right? And this is what we're talking about, the formal charge. So the charge is drafted, and then in court, when the accused is brought to court, either because he was arrested or because he's out of on bail or was warned to court and has come on of his own volition, but now he's in court ready to answer charges, answer and make a case in defense or in his defense. This charge is then read out and read out to the accused person. It's read out to the accused person, and the accused person then is asked to plead. Now, there's several things that can happen. Instead of pleading, he can choose to object, and we'll look later, and you'll see on the audio and you'll see in the slides and notes what objecting to a charge is, and that could be that the charge is deficient or vague or any of a number of factors. But if that's not the case, then the accused person pleads. And for our very limited understanding at this stage, the plea could be either guilty or not guilty. But when we look at the next set of slides under pleadings, under section 106, we'll see that there are very many other types of pleadings that an accused person could make. But once that happens, once the plea is in and recorded by the magistrate, now the trial can actually start, okay? So this charge, now we've been doing criminal
Yes.
law, we've been doing specific offenses, and we've been talking a lot about why it's about the elements of the crime, knowing the elements, what it means, what causation means, how do you prove causation, what is intention, how do you define, if you're looking at rape, how do you define penetration, etc., right? So in drafting this charge formally and putting it to the accused, what the prosecutor is doing is putting the accused in a position such that he knows the charge, reasonably knows what he's being charged of, and that then puts him in a position to be able to answer that charge. But if the charge is vague, if the charge doesn't contain an offense, or, the way it's drafted doesn't look like an offense. So if in the crime of housebreaking with intent to commit a crime, the prosecution merely says housebreaking and doesn't allege the other crime, so theft, robbery, rape, or as we saw last semester, housebreaking with intent to commit a crime unknown to the prosecutor. The accused then could object and say, well, what am I defending? You haven't even charged me of anything that's, whatever you charge me of isn't even a criminal offense in our law, or common law or statute, right? So there are various essentials in the charge. And we look at one example, right? So the prosecutor stands up and he says that the accused is guilty of the crime of housebreaking with intent to steal and theft, in that on or about the 3rd day of September 2020 in Allendale in the district of Pietermaritzburg, the accused did wrongfully and unlawfully break and enter the house of Jerry Jones with intent to steal the goods therein, and did then and there wrongfully and unlawfully steal the following: a Sony TV, Panasonic Hi-Fi, T5 microwave oven, and a BMX bicycle, the property or the lawful possession of Jerry Jones. Now, let's go back to this slide when we talk about Section 84 and the essentials of the charge. Now, why is it essential that things like what the offense is, the time and place that it occurred, against whom it was committed, and if it's property, list the property? Why do you think it's important that we do this, that it's done properly? Well, because of the rule of audi alteram partem, fairness, and legal certainty. Absolutely. Let's look at this charge again. Let's look at this charge again. This informs the accused of what crime he is accused of having committed, right? So he knows why he's in court, and for his defense and for the prosecution, this means that the prosecution has to prove the elements of housebreaking, so that there was a breaking in, that the entry was unlawful, that it was not justifiable or excusable or lawful, okay? And further, entry into the property also had a further malicious purpose, theft, robbery, whatever the case may be. So it's for the prosecution now, and for the court hearing the matter, and for the accused, we need to show that those elements are what is going to be proved in court. Other things are obviously important: the date, time, place, locale, because those sorts of things set up, well, the locality, sets up jurisdiction. The date and time is relevant because the accused person may well have an alibi for that, or reasonable reason as to why. Okay, fine, I'm not in dispute with the fact that I took the TV, but given that date and that time, I was there with a particular purpose, right? Stating who the property belonged to. Now that goes to proving that if you're talking about theft, one of the requirements one of the elements is that things stolen must not belong to you. Now, it must be a thing capable of being stolen, and you must have no rights over it, okay, if you're the person taking it. And here the allegation then in the charge is that the thing that was taken, essentially stolen, did not belong to the accused, and therefore he did not have, as you can see, rights of lawful possession over it. He exercised those rights over and above what the lawful owner or possessor had. And then the nature of things, or the list of things that were stolen: Sony TV, Panasonic, Hi-Fi, T5 microwave. Again, depending on what the accused version of events are, he may well have a legitimate reason why he entered the property and why he took possession of those items. We don't know, right? Yeah. So the charge then, if the charge is scant, if it is vague, if it doesn't show a criminal activity, so something like unlawfulness, or something like, if we're talking about rape, consent, those sorts of key elements are left out, and the accused person, and obviously there are very many other factors that to which an accused person can make an objection to the charge, means that instead of pleading, he's objecting to the charge. He says, look, I refuse to plead because there's no charge to answer here. You named the wrong person. I am not the S. Bamji that you're looking for. I'm the wrong S. Bamji, or, those sorts of things, whatever the case may be. But again, this objection must be made, give the prosecutor enough time or forewarning that the accused intends to object to the charge. If the objection is valid and acceptable by the court, the charge can be, in colloquial terms or old-fashioned speak, quashed. Doesn't mean it goes away, it's just being quashed. And because the pleadings haven't, the accused person hasn't pleaded yet.
What does that mean?
Okay, so it means that it's scrapped. Quashed pretty much means scrapped. And if it's done before the pleadings, it means that the state can go away, fix the charge, amend the charge and come back with a proper charge. Certainly come back with proper accused persons. And quashed is now, it's an
Okay.
old-fashioned way of saying that, but it doesn't mean that it's gone forever. That's very different from when we talk about, and we talk about what happens once an accused pleads. So once an accused pleads,
Okay.
even if the state hasn't presented any evidence, hasn't presented its case, and this is why the Section 106 pleadings are important. An accused is, once he's pleaded, entitled to a verdict. So once he's pleaded, the court must, however long it takes, or however soon it takes, declare that he is acquitted or convicted, right? Guilty or not guilty. Which means when we talk about those Section 106 pleadings, right, particularly the principle of double jeopardy, means that the state can't come back and charge him again of the same offense, because essentially he's been acquitted or convicted, right? So yeah, quashing of the charge before the pleading is done, right, at where the accused person makes an objection, means that the state can bring back another charge, because nothing's been decided on the merits yet. Nothing's been decided on the merits yet. No evidence essentially has been led, if it's early enough, right?
Okay.
Okay, and we hear this phrase a lot. It's being quashed, but it doesn't mean that you've been declared not guilty.
Okay.
It just
I
means that,
have another question.
yeah, sure.
Mm,
Go ahead.
okay. No, it's about, like, let's say in an exam question, because like here it says, oh sorry, that's if the charge, let's say it's can now, we've got the act that talks to that it doesn't necessarily mean that the person won't be charged properly. Do you have to discuss the situation before the act?
I don't
That's
follow.
because now you can be charged even if the charge had not been properly.
Now, see, depending on the
Because
nature
you know,
of the
like how
defense,
when the charge is written,
yeah.
like it's supposed to be properly written, but if it hasn't been properly written.
All right. So when we talk about objections to the charge,
Yes, I'm just asking, like in
always-
terms of exam question, do you have to like explain the history? Yes.
okay, so before I answer your question, let's just talk about the practicalities of how that will work. So a defective charge can be fixed,
Okay.
right? And if what is defective is small enough so that it doesn't mean that the accused person will be prejudiced, it can be fixed pretty much immediately, right? By reading into the record. And if you remember, I don't know if you watched the Pistorius trial, right? When is it Harry Nell? When Advocate Nell was reading out the charges from the charge sheet, charging Oscar Pistorius, he read out the charge and then he said, my lady, I need to make an amendment to this charge because the date was recorded as, I think they got the year wrong. They got the year wrong. But the date and the time was correct, but they got the year. So 2000 and whatever was incorrect, right? And the court recorded that amendment. They then turned to the defense and say, are you okay with this amendment, or are you taking an objection to the charge? And they said, no, we accept the amendment.
Mm-hmm.
So now obviously you can see that something like a date would be material, okay? But the parties were in agreement that yes, this is just a genuine typo, and it's not something that would be disputed in evidence. So in that case, it wasn't quashed. and the state didn't have to go back and start afresh. But where there's something more material, like they need to check. So the charge says theft, but the evidence that's going to be led, or the accused is under the impression that he's there for rape or something else, right? Hijacking or negligent driving.
Yes.
Then there's something
Yes.
manifestly wrong with that charge. So you see why also, and this is also important to the law has, and we understand that in criminal procedure, although we said criminal procedure is a game of rules, right? Me knowing the rules better than the other guy, me being able to apply the rules, understanding the rules, understanding the technicality. Although we say that, and I think you raised this, Rebecca, at one of the lectures, that it seems unfair
Yes.
to just let someone get off on a technicality, right? And the law wants to, and law of criminal procedure wants to avoid that,
Yes.
wants to avoid that. And so we allow for reasonable amendments to charges where it can be done in a way that the prosecution, sorry, the defense will not be unreasonable, unjustifiably prejudiced. So this sort of objection, and you'll see that so they'll say, well, you say housebreaking, but you're not telling me where or when. So then the prosecution would be, like we see on the slide, obliged to give further information so that the accused can properly make a defense. Because without the information of where, when, against whom, and what was stolen, what sort of defense is he meant to make? Or we charge you because we think you stole things on a day. Doesn't work. So
Yes. No, it makes sense.
yeah, so to prevent the winning or losing, because we don't want it simply to be a tick box exercise of winning and losing also just on technicality. We want to see merits, we want to see actual justice. And so to assist in the process, to keep the cogs in the wheel turning, these sorts of amendments are allowed, provided, of course, they don't lead to undue prejudice of the accused. And the question against, is the accused prejudiced by an amendment, by a court of justice allowing an amendment to a charge, comes down to the question of this: would the accused have made any other type of case or made any other type of defense? So if his version of events and the evidence and the types of witnesses he or she would have called would have been different if the charge had been made properly, then we can say that yes, the accused would have been prejudiced, and therefore we can't allow this amendment. Again, with amendments being made particularly later in the trial. Sometimes the accused doesn't make an objection to a charge, but it transpires through the evidence that what is purported to be proved is a little different from what the accused person was being charged with. And that again goes to the question of prejudice. And the question comes down to, well, despite the fact that the charge may have been, let's call it, slightly incorrect, has the accused still managed to put a defense against, and has evidence been led in a way that the accused person is answering the charge proper? And this is what we say that the what's what defects in the charge. Defects in the charge can be cured by evidence. Sorry, there's a chat. Yes, no, I'm also having connection issues. It took me quite a while to log into to Moodle. It took me quite a lot and time to log into Zoom, and it keeps telling me that my connection is unstable. So we'll carry on as much as we can. Right. So have a look at this stuff on objections to the charge, and particularly this defect in the indictment or charge sheet that can be cured by evidence. And I think the audio and the notes on that will make it more clear. Also corrections in the charge. Yeah. So that's pretty much all I really want to say about this, but I do want us, so please go through the audio, go through the notes and the slides, and just pick up on those pointers that I brought to our attention. What I do want us also to look at, the next set, is please. Arraignment and
Sorry, Ms. Ramjit.
yes, Tunika.
The genre of offenses.
Okay, let's go back.
I'm not sure if I understood it like correctly.
Okay, joinder. Okay. All right. We talk about joinder of offenses and we talk about joinder of accused or separation of trials. So what do we look at is the factual scenario. The factual scenario. So let's say in an act of robbery. In an act of, robbery is theft with violence. So it means theft plus assault. So the question is, would that be a separate charge of theft and a separate charge of assault, or would it be treated as the crime of robbery, right? So we talk about joinder in that sense. Also, let's say in a broader example.
Oh, okay.
So no, that's just the start. That's just the start. Now, before I could get to the scene where I committed the robbery and the assault, I also had to hijack, or I did hijack a motor vehicle. And I assaulted someone there as well. But all of these events are tied to each other to be one factual scenario, strictly speaking. Right? So the question is, if we join in, we can talk about count 1, count 2, and count 3, right? But have it all happen in one trial, rather than the accused person called for trial number 1 in court A, trial number 2 in court B, and trial number 3 in court C. So it's cost saving, and also it's logical because of the scenario. It's going to be pretty much the same witnesses and the same evidence being brought in 3 separate trials. And you also, why it's important that certain offenses are joined and trials are joined in this fashion is because you need to look at what the cumulative effect of sentencing is. And you don't want to have a situation where accused persons are sentenced twice for something which is essentially the same offense. So look at another example in the audio and in the notes. We make the example of, let's say, a charge of rape. And there you've got one accused, you've got one victim, but this accused person is actually a blood relative of the victim. So that's a charge of incest. The sex was unconsensual. So you've got now a charge of rape. The person who was sexually assaulted or sexually abused or raped was a minor. So now you've also got a question of statutory rape. Now, would you charge that? And this is again where we goes into the second leg of this, which goes into duplication of convictions, duplication of charges. If we're talking about joinder, would it be one charge of rape, one charge of incest, one charge of statutory rape, or would it be just rape? And then we need to talk about the question of competent verdicts as well, depending on what sort of evidence was laid, or charges in the alternative. All right. So it's explained a lot more clearer in the audio because I've had more time and I can refer you to the cases and stuff like that. Did you, Tabeka, did you manage to listen to the audio and go through the notes a bit?
Yeah, I managed to go through the audios and notes. I was a bit confused with the alternative charges versus competent verdicts, but I think I'm like sorted with that one. But I'm just thinking, in a case, let's say a person kills 3 people, like at once.
Yeah.
So, because usually, like when you see in television, they would usually say like maybe they're charging them on 3 accounts of murder.
Counts of murder.
But like if it's like let's say a person just opened a gun and 3 people died, like would that be 1 account of murder or 3?
Wait, I lost you. I lost the audio.
Okay, no, sir. I was just saying that's like because like at some point they were talking about.
No, I've completely lost your audio, Tabeka.
I'm so sorry. I'm using another phone.
Okay.
Okay. No, I was just saying that because if like they were saying that if something happened in one action, like let's say that the person just opened a gun and then 3 people die. So you could look at that as 1 murder or
no, that will be 3
3 murders. Like we
but it will be
see on
done
television.
in one trial. It'll be 3 murders done in one trial. And they'll have to look at intention, because all of the elements for each of those, right? Murders. And in the end, he will be found guilty on charge number 1, guilty on charge number 2, guilty on charge number 3, right? And then the sentencing will happen. So we look at cumulative sentencing that.
Okay, even if he.
So like, you know, like how you read in the headlines, a person charged with and found guilty of 205 counts of fraud. It would have, that hearing would have happened in one trial. There wouldn't have been 205 separate trials.
Okay.
Okay. Because I mean, think about it, 205 different courts. And that means moving the accused person around all the time, getting witnesses up and down all the time. So again, it's about practicalities, making justice actually workable, right? And obviously for fairness. All right, so we're okay with that then.
Yes, thank you.
All right, thanks, Tabeka. All right, so we can go into then this thing about arraignment and pleadings, and I discussed arraignment to you when I was talking about the charge. It's difficult to separate these issues because they lead into each other. You know, they lead into each other. So we know what arraignment and pleadings are. But again, like we said, the accused person must be given enough notice about the charge, and that allows him to work out what his plea is going to be, and further what sort of evidence he's going to lead in his defense, which witnesses, etc., are going to be called. And that's why it's important to get the charge drafted properly. So when an accused person is arraigned, assume that all of that has happened properly, and the accused person is asked to plead. We saw that he could object to the charge. Alternatively, he could just not want to plead, right? Not want to make a pleading. And in what that means is that if an accused person, although he's being charged, if he refuses to plead, it means that the case cannot happen. Technically, if an accused person doesn't make a pleading, the matter can't start. The state can't start leading evidence. And so to avoid this sort of stalemate, there are a mechanism built in criminal justice, in the various sections of the Criminal Procedure Act, which allow for the court to dispense with the plea, or enter on behalf of the accused a plea of not guilty, where he refuses to plead or where his plea is ambiguous, right? Um, and you might say, well, ask the question, well, isn't that prejudicial? You're forcing a plea out of him. And essentially, the justification or the constitutional aspects of that have been considered. And they said, entering a plea of not guilty on behalf of the accused where he refuses to plead or has been obstructive, rowdy, etc., as we see on the slide, will not be a constitutional violation, because the accused, the state is still required to prove the allegations. And still, even when an accused person does plead not guilty, he can still decide not to give any testimony, offer any testimony. And so it will still be up to the state to prove beyond a reasonable doubt those factors. So have a look at this sort of stuff. Now, one of the things I wanted to bring to your attention is this notion of plea bargaining. What do you think plea bargaining is? And what do you think plea bargaining means?
Yeah, if someone wants to get like a lesser sentence, or they want they want to get like a lesser sentence, or they want, yeah, and by asking, or maybe like saying someone else was with them.
Okay, so plea bargaining would work in a traditional sense, and also in terms of the codified version would work in this sense. Let's say an accused person is charged with murder, right? He fears that if he is found guilty of murder, he will be given a very, very harsh sentence. And so he enters into a plea negotiation or a plea agreement with the state and saying, look, I will plead guilty, but to a lesser charge. So I'm happy to plead guilty to culpable homicide. Or you intend to charge me with murder dolus eventualis, I will plead guilty to, murder dolus directus, I will plead guilty to murder dolus eventualis. And that means that the state would not have to actually and actively, in the sense of terribly adversarial, please listen to the words I'm using, prove all of those elements in court, because the accused will admit those elements, in exchange for a less serious offense. And what Thobeka was also discussing or raising the point about is where an accused person will say, okay, I'll plead guilty to murder in exchange that you do not charge somebody else or the other person or the third person, right? And that, in a sense, is acceptable. But what differs from traditional plea bargaining and the Section 105 plea bargaining is that the court cannot be held, and well, this is true, that although parties may have between the state and the defense, have agreed to a particular pleading, and the state is prepared to accept it, it's still up to the court to accept that plea. The court could say, no, we're not accepting this plea. Alternatively, and remember also that the state and the defense would have also entered into a sentence agreement. The sentence agreement also doesn't bind the state. The court doesn't bind the court, meaning that if the state says, look, we're prepared to accept your plea of guilty, but as far as the sentence is concerned, no, we think this is far too lenient, and we will probably be looking to give you a more harsh sentence. Now, if the court was bound by these sorts of sentence agreements, and if the court was also bound by plea bargaining, you could see that people could get away with very, very light sentences, very, very light convictions, and literally slaps on the wrist. And so the court still acts as an independent arbitrator and has judicial discretion on whether or not it is accepting the plea, and further whether or not it is accepting that sentence agreement. And if the court doesn't accept the sentence agreement, it will say to the accused parties, look, we are not prepared to accept the sentencing agreement, which means that so up until the stage that plea hasn't been formally recorded, so the accused person can withdraw, and the state can then withdraw from this agreement, and the matter must start afresh on the original charges before a new court. Alternatively, they can say, no, we're happy to stick with this sentence, with this plea that we've agreed, but we leave it up to the court to make a sentence which it deems fair. So that's plea bargaining in a nutshell. So the pleadings that an accused person can make, we understand and know generally as guilty and not guilty. But when we look at Section 106 of the Criminal Procedure Act, we see that there are very many more. And the two that I want us to pay particular focus on are these two, which is the double jeopardy principle. So when an accused person is asked to plead to a charge of murder for having murdered a particular person, instead of pleading guilty or not guilty, he will say, well, I plead that I have already been acquitted of this charge, or I've already been convicted of this charge. And this is what the terms atrefwa acquit and atrefwa convict are, and where they come in. So I've put up, I think, the audio, and there's also several readings for you. Particular focus on the case of the State versus McIntyre, which looks at this scenario. The scenario being that the accused were tried for assault and found guilty of assault, and then afterwards the state tried to, for the same set of facts and the same victim of the assault, the state then wanted to bring a charge of murder. And the question is, well, can that be done, or could the accused in that scenario successfully raise the pleading to this new charge of murder, albeit on the same set of facts, of atrefwa convict or atrefwa convict? And the facts of that matter was that the person who died in that assault died that very evening of the assault, and it was the police who failed to inform the prosecution that the accused had passed, that the victim had passed away. So have a look at the facts of that case, have a look at the readings, and see what the requirements are for successful raising of a plea of atrefwa convict and atrefwa acquit. Again, like we said, Rebecca, because this is what you raised, it is not simply about a battle of technicalities and winning on technicality, right? So it's not like you can say, oh, no, this charge was quashed, right? It has to be on the merits. And that's one of the factors that the courts look at. Yeah, and then have a look. I think this stuff is pretty self-explanatory regarding pleas of guilty and pleas of not guilty. But even so, when an accused person, so let's talk a bit about pleas of guilty. When an accused person pleads guilty to court, courts do not just simply accept it. This is where the court, again, as we saw in bail, where the court takes a bit more of an inquisitorial role as opposed to being an independent arbitrator, particularly. The court will descend to an arena, but again, in a limited sense, and it'll ask the accused particular questions. And the nature of the questions is not towards the merits of the case necessarily, but more engineered towards working out whether the accused person, in fact, pleads guilty. In other words, does he properly understand the charge made against him? And does he possibly, because particularly when he is an undefended or unrepresented accused, or someone who is not legally minded as we are, does he have an actual defense? And so although the accused person may have entered a plea of guilty, on questioning, it may appear to the court that the accused person does have a defense, possibly. which the state must deal with in a trial under a plea of not guilty. And so in terms of section 113, the plea will be changed and entered on behalf of the accused from from guilty to not guilty. Yeah, so this is the stuff that we were talking about when we spoke about atrefoi acquit and atrefoi convict. And like I said, please look at the McIntyre case. I think there are two readings put up on Moodle for you as well. And this is a nice assessment question. Yeah. All right, so that's all I have to say about that. Do you have any questions for me?
In the tutorial, you talked about a statement where you talking about the charge, like how to write the charge.
Which one was this? Which question? I've got the things in front. Oh yeah, draft your client's statement. No,
when you said we should write this,
we haven't, because that's a practice exercise and we have to be in class for it. This is, so you can see this one. You're looking at this one about drafting the section 115 plea itself. Don't worry about that. Don't worry about this question at all. Can you see it?
Okay.
Can you see it gone? All right. Don't worry about that one. Okay. But this is the type of scenario. This is the type of scenario that we're talking about when we're dealing with State versus McIntyre, and the question of, so the facts of this one are very similar to the facts in McIntyre. They have been tweaked a little. Now you might get a problem question like this, but because of what it's in list, it means that you've got to write an essay as well. Alternatively, the problem scenario part of it could be left out and you could just be doing a discursive essay. So work on that type of thing as well. Yeah, so again, this one's gone because I'm not going to ask you to draft a guilty plea and a not guilty plea, because that's meant to be from memory. It doesn't help if you've got the precedent in front of you and you're just copying. All right.
Okay.
All right. Okay. So other things I need to tell you. So the assessment will be released next week. Next week is the 1st of December. Is that correct? Yeah, next week, Tuesday is the 1st of December. It will be released at 8 p.m. after our Zoom session on the trial. So it will be released at 8 p.m. We need to work out, and we'll work out with the full-time class what time in the evening on the Wednesday we can meet to discuss any question that you guys have, as we've done with all the assessments. And then the assessment is due on the 8th of December. Okay, at 2300 hours. Okay, guys?
Yes, ma'am.
Okay, great, great. Any further questions? Okay, so I will see you all next week. Next week what? Next week, Tuesday. I think the stuff for the notes and audio for the trial have also been uploaded, so please work through that. And we need to go through that as well before the assessment. All right.
Okay, thank you.
Okay, thanks everybody. Have a pleasant evening.